Good morning, everyone. My name is Christy McKenzie. I'm the Assistant Coordinator of Neighborhood Services with the Erie County Department of Senior Services. I would like to welcome you all to our 2021 Virtual Elder Law Day Summer Series. This series will continue to run throughout the summer, including a variety of topics every Tuesday and Wednesday at 10 a.m. I would also like to take a minute to thank those individuals who have helped make this summer series possible again this year, including our County Executive, Mark Kolenkars, the CEO for Center for Elder Law and Justice, Karen Nicholson, and our Commissioner from Senior Services, David Shank. A few things to mention: this program will be recorded and will be available later on YouTube. To ask any questions, please use the Q&A panel down on the bottom right. If you have any questions, we'll try and answer them during the presentation. Please allow me to introduce our guest speaker, Linda Grear. Linda is a partner with the firm of Pfalzgraf, Beinhauer, Grear, Harris, Schuller, and she practices in areas of elder law, estates, estate planning, and guardianship. Linda is also a member of the New York State Bar Association of Erie County and a member of the Circuit Court and Elder Law Committees. Welcome, Linda. I'll turn the presentation over to you.
Thank you. Thank you very much, Christine. So I do want to thank Christine McKenzie at the Erie County Department of Senior Services for hosting today's virtual event for me and getting us all set up. And as Christine mentioned, if you do have questions as we progress, please put them in the Q&A, and Christine's going to monitor that for me. And hopefully we can have all your questions answered as we're going through things. So if you think of something, you have a question, feel free to ask. And we do want today's presentation to be as informative and educational as possible. And so I will get started. Whenever I talk about estate planning and elder law, I generally start with basics and then layer on some complexities as we go. There are 4 basic estate planning documents that all individuals should really have and consider putting in place if you don't already have one. So the first of the 4 basic documents is a last will and testament. And a last will and testament is essentially a list of instructions to be followed after you pass away. It allows you to designate within the document who's going to inherit your estate, specific bequests that you might like to make to individuals. And it also allows you the opportunity to appoint the person that's going to wrap up your final affairs after you pass away. That person is known as an executor. You can pick multiple people to assist you with that. You can have a primary person, a successor. If you have multiple children and you want multiple executors acting, you certainly can do that. Keep in mind, however, if you select multiple executors, they do have to work together, so they have to be able to communicate well with one another as they progress through the process. A last will and testament also allows you the opportunity to put into place certain protections for individuals who might be inheriting. So, for example, if you have children or grandchildren who might be minors under the age of 18, you may not want them to inherit until they're a little bit older, a little bit more mature. We can actually put trust provisions into a last will and testament that would provide for them and to assure that they don't inherit until they're a little bit older and more mature. Also, if you do have somebody in your family that has a special need or developmental disability, those people need to be protected as well. So a person who has, for example, a developmental disability and who might be receiving supplemental needs income, like SSI income, through the Social Security Administration, it is important to know that that individual cannot have more than $2,000 of assets in their own name at any given time. And if they suddenly inherit money with the best of intentions, we've suddenly knocked them off of their government assistance. So they would lose their SSI and then their Medicaid tied to that. We want to make sure that we're protecting our family members and providing for them, not hurting them. So we can do a trust provision in a will that provides a supplemental needs trust for someone so that the money is protected for them, but they don't actually own it, and it can be used to enhance their quality of life for later down the road. So if you have somebody in your family who's a minor or maybe not that great with money, or if there's something going on in their life that they really shouldn't be inheriting the money outright, keep that in mind, that in your will, we can actually put protections in there for them. It's also important to know that a last will and testament is really not even relevant or looked at until after you pass away. So that is only going to govern assets that are in your name when you pass away that don't have a joint owner or a designated beneficiary attached to them. If you have a joint owner on an asset or a designated beneficiary, or if prior to your death you've transferred ownership of specific assets out to either another person or to perhaps a trust, that's going to take those assets outside of the purview of your will. The will is only going to govern what's left in your name at the time of your death. So does anybody have any questions on the will? Pretty basic. No, excellent. So the next of the 4 basic documents that I want to talk about is a disposition of final remains. Oops. And a disposition of final remains is essentially what your funeral or your burial instructions might be. So when you pass away, you have indicated in advance, when I die, I would like this to be the plan for my final remains. So it could be, I would like to be cremated. I want my cremated remains scattered in a specific location. You might want to be buried in an earth burial or in a mausoleum, whatever your wishes might be. You can do a legal document that puts those wishes into writing. The really nice thing about this legal document is it can avoid disputes among family members later. So this is particularly helpful if you're in a situation where maybe there's a second marriage. We have a new spouse and children from the first marriage who they have different ideas about what they want to do after you pass away. And this can avoid all of those disputes. And funeral directors under the law will follow the directions of whoever you've appointed as the agent. So the law provides for this to take away some disputes among family members that might be existing. Within this document, you may designate whatever your wishes might be about religious services or cultural preferences, whatever that is. You can put this into the document. And again, funeral directors really like to see this document because they then know directly who they're taking instructions from. They also know what your wishes are, and they can then follow and make sure that all those things get taken care of. So pretty straightforward. That's the second of the basic documents. The third of the basic documents is a document known as a healthcare proxy or a healthcare directive. And in New York, it's actually important to know we have 3 different kinds of healthcare directives in New York State. The first is just a healthcare proxy, and that's a basic document that appoints a person. And it just says, I appoint my husband to serve as my agent. And it just sort of says that, and it doesn't go any further. So that's just a healthcare proxy. It appoints a person to step into my shoes if I cannot communicate for myself, to speak for me. Keep in mind, your doctors are always going to speak directly to you. So if you have the ability to indicate what your wishes are to your physician, they're going to be taking directions directly from you. The healthcare proxy or these healthcare directives are only looked at if you cannot communicate what your wishes might be. The next of the directives is a living will, and that's a little bit more specific. It allows you to specify specifically whether you would or would not want to have life support, so feeding tubes, respirators, those types of things. And that can be artificial nutrition or hydration, so food or water. Your wishes one way or another about whether you would want those things. You also have the ability to indicate whether or not you would want to be an organ donor, and you can do that in the living will documented as well. And lastly, of the 3 healthcare directives, we have something called a medical order for life-sustaining treatment, or a MOLST, M-O-L-S-T. And a MOLST is for people who have very specific wishes, do not want interventions, and you do a MOLST directly with your physician. So it is a brightly pink colored document. It's like a fuchsia pink. It's easily identifiable so that if there's, let's say, an emergent event or a crisis and emergency medical technicians are coming to your home, I would recommend that if you have a MOLST, you keep it on your refrigerator so that they can easily see it. They can pull it down and they would know what your wishes would be with regard to life-sustaining treatment. So if you do have very specific wishes, I recommend that you do a MOLST, and you do that with your physician, and then you keep it easily identifiable within your home. Any healthcare directive that you do should contain HIPAA language. That's health insurance portability and accountability language. And that's really just authority that you've granted so that your agent can talk to your medical providers. Because if you call for someone else, another adult, the doctors are going to say, we can't talk to you, we don't have authority. We need to make sure that that authority is in there. So any of these documents should make sure that they include language to grant authority to your agent to be able to talk to all of your medical providers. All right, any questions on any of the first of the three basic documents that we've covered? Nope. Okay, great. I'm going to move on to the power of attorney. So the fourth of the basic documents in New York State is a general power of attorney. And a power of attorney is a legal document that we put into place to allow somebody to make decisions for us with regard to our financial or household business transactions. So this could be the ability to buy or sell real estate, deal with our banking, deal with insurance companies, file a claim or a lawsuit on our behalf, file our taxes. All the stuff we would ordinarily do for ourselves, but if we are unable to do these things, somebody that can step right in and take care of these things. Now, it's important to note in New York, we have a required form. We actually have a standard form for power of attorney, and we have a new form in New York that became effective just last month. So June 13th of 2021, a new power of attorney statute went into effect in the state of New York. And essentially, any document that is executed in the state of New York as a power of attorney needs to substantially comply with this statute. So it needs to follow the format that the legislature has given to us. It is important to know that any documents that were previously executed in New York as a power of attorney are still effective. So if you signed your power of attorney before the change in the law, that's okay. It doesn't mean that your old power of attorney is invalid. It's just that any new documents do have to follow this format. One of the things that we've done here in the power of attorney statute, and what they've done is they've tried to shorten up the power of attorney. Previously, we needed to have a separate rider to the document if you wanted somebody to have the ability to make larger gifts for you. And a gift is taking an asset out of your name and giving it to someone else. Previously, the document required a rider, and then so you had two pieces of paper that had to be read, or two documents rather, that had to be read together. And the document was like anywhere from 11 to 13 pages in length, and they've tried to shorten that down a little bit. It's still pretty comprehensive and lengthy. It's still going to probably be about 10 to 13 pages in length to be totally comprehensive and cover everything, but it is combined, shortened down. We do not now have a separate rider. They've also put some teeth into the statute to say that if a bank or a financial institution gives your agent some difficulty in dealing with using your power of attorney, there's some consequences to the banks for that. So oftentimes in the past, if an agent presented a power of attorney to a bank might say, well, this is too old. It's on an old form. We don't want to accept it. They can no longer do that without penalties unless they have any reasonable suspicion that there's some sort of fraud or something like that. There's something wrong with this document. Otherwise, they are required to honor the document. They've always been required to honor the document, but now there's actually some monetary penalties to them if they do not honor the document. So a power of attorney is important for all adults. Anybody over the age of 18 really should have a power of attorney. It doesn't matter if you have a lot of assets or not. If you became incapacitated, you would need somebody to step in and help you with paying your bills and maybe even applying for Medicaid or other benefits that might be out there. So it's really important to have the power of attorney in place. It's important to make sure that you have selected appropriate persons as your agent. In a power of attorney, you are giving somebody a lot of authority for you. So you want to think about, who do I trust? You could have multiple people. So if you have a few children, you could say a couple of my children. You could require them to act together so that there's some protection that they must do everything together. Or you may say that either of these people may act for me. That's totally fine. So you have the opportunity to appoint a primary, a backup, multiple people. You have a lot of flexibility in a power of attorney. The biggest thing I would recommend is that you assure that your power of attorney does give your agent the ability to make gifts. And gifts means the ability to take an asset, $5,000 or more, out of my name and give it to someone else or give it to a trust. And I recognize that it seems strange or counterintuitive to let somebody else make a gift for me, but there are legitimate reasons why it comes up. And it's either going to come up for tax planning. or more frequently for protection of assets from a nursing home or Medicaid scenario, which we are going to be talking about today. So if you're going into a nursing home scenario, there is a very real possibility that we need to move assets out of your name over maybe to your spouse or to your children or perhaps to a trust. And we need to make sure that there is authority for your power of attorney agent to do that for you. And I think a couple questions popped up while I was talking, so I'll ask Christy to just let me know if there's anything there.
There is one. Does a power of attorney have to be recorded?
Oh, good question. A power of attorney is not required to be recorded unless it is being used for a real estate transaction. So a power of attorney is a document that's private. It's your document. You're not required to put it on public record unless it's being used and your power of attorney agent is actually using that document to either sell or purchase a piece of real estate for you. In that situation, then the document would be recorded. There's nothing wrong with recording your document if you want to, but then it makes it public record and anybody off the street can then see your document. If they went into the county clerk's office and typed in your name at the computers, they would then see a copy of your power of attorney. If you don't have a problem with that, that's fine. But most people do not want to record their power of attorney unless they absolutely have to. And again, it's only going to be required if it's in a situation for buying or selling a piece of real estate. Any other questions on the power of attorney itself, that fourth basic document? No? Okay, I'm going to move on to sort of the next layer of complexity. So we sort of start with basics and we start layering on complexities. So the first layer of complexity is to discuss estate taxes. And the good news is that most people that I work with don't really have an estate tax issue because the estate tax thresholds are quite high as they currently stand. So right now in New York, the current estate tax threshold is $5,930,000 per person. So if you have $5,930,000 or less, you don't have to worry about estate taxes in the state of New York when you pass away. The current federal estate tax exemption as it currently stands is $11,700,000. So again, unless you have more than that, you don't have to worry about estate taxes after you pass away. And this is per person. So if you have a married couple, each spouse has these exemptions. Now, it's important to know that current legislation as it's currently written, the federal exemption is scheduled to sunset. So it's currently $11,700,000. It is currently scheduled to sunset on January 1st of 2026, back down to where it was with tax reform. But it's still going to be over $5 million of assets. Now, there's been a lot of discussion and scuttlebutt in the media, particularly about, whether the new administration is going to change the state taxes or, whether we're going to lose some of the current exemptions that we have. I have no idea if those are going to actually happen, if that legislation is going to pass. I do know what we do know right now is this is what we're currently dealing with. And again, most people don't have an estate tax problem, but if you find that you are approaching these levels, by all means, work with somebody, work with an attorney that can help you to try to minimize estate taxes and come up with ideas for what we can do. So if you are approaching those levels, just simple things to think about. On an annual basis for tax purposes, you're allowed to make annual exclusion gifts to help reduce the size of your estate. For example, right now you can give up to $15,000 per person per calendar year to as many different individuals as you would like, and you don't have to file it as a reportable gift. However, any gifts that are made you have to consider for Medicaid purposes. So this is a freebie for estate tax and gift tax purposes, but not for Medicaid. We're going to talk about that later this morning. But if you're in these higher levels, you can make an annual exclusion gift of $15,000 per person per calendar year. You can do charitable gifts to help reduce the size of your estate tax after you pass away. You can also, in addition to making those annual exclusion gifts, pay for medical expenses or education expenses for maybe a child or a grandchild. As long as you pay the provider directly, you can make that payment in addition to the annual exclusion gift that you can do for gift tax purposes. So again, not too many people that I work with on a daily basis find themselves in these estate tax thresholds, but if you do find yourself there are ideas that we can come up with and help you to try to reduce and minimize some of those taxes. The more frequent scenario that I'm dealing with is sort of the other end of the spectrum, and people are worried about going into a nursing home and protecting assets from that nursing home and Medicaid planning. So that's what we're going to kind of get into next, that next layer of complexity. Before I move on, though, I just want to ask Christine, any questions popping up there? Okay, great. So the next thing I want to talk about is that next layer of complexity, and that is planning for the nursing home and how do we protect assets and what can we do there. And that conversation really needs to start by thinking about, well, what does a nursing home cost, or what does long-term care cost, and then how do we pay for that? So the average cost of care in a assisted living facility, which is a little bit lower level of care, here in Western New York, the average cost of care for that on a monthly basis is about anywhere from $3,000 to $6,000 per month to go to an assisted living facility. And in that type of situation, maybe you need assistance with meals and medications, but you can dress yourself and ambulate around and transport yourself from bed to other locations. So you can do a lot, but you maybe need some assistance. So that's the lower level of care. When we start talking about skilled care, custodial care in a facility, that's a person that really needs help with all activities of daily living. And the cost for a custodial assisted living type of situation is going to range anywhere from about $12,000 to $16,000 per month. So that is expensive. And we think about, well, how are we going to afford to do that? That's a lot of money. How am I going to be able to maintain myself if I needed to go into a nursing home situation? So essentially, there are 4 sources of payment that we look to when we start talking about the cost of long-term care. The first source of payment is private pay, and that means I just cut a check to the facility every month as I go. So I'm cutting a check for $16,000 to the facility every month, just paying my own way. That's certainly a viable thing, but most people, A, can't afford to do that for very long, and B, don't really want to deplete their assets for doing that, because then there's not going to be any left for the kids or grandkids. But that is the first option. We have private pay. The second option or source of payment that we look to is long-term care insurance, or a separate nursing home insurance that an individual might have. And frankly, most people don't have it. It's kind of expensive to get. And sometimes people, as we get older or have health issues, we can't get that insurance. But it is one thing that we do need to look to. Do we have any nursing home insurance out there? Okay, if we do, we want to use as much of that and exhaust it. And so that we're not privately paying, we're using that insurance if we can. Bringing us to the third source of payment, and that's going to be Medicare, different than Medicaid. Medicare is it's going to be your hospitalization coverage that you have through Social Security. So it's an entitlement that you have. If you've paid into the Social Security system and you have your little Medicare card, Medicare is going to cover hospital stays, and they're going to cover short-term stays in a facility following a hospital stay for a rehabilitative type of situation. So as an example, it would be you fall and break your hip and you have to have surgery at the hospital, and then you go out for rehab, physical therapy, occupational therapy. In that situation, Medicare is going to cover the hospital stay. They're going to cover the first 20 days of the rehab, totally in full, no copays or anything like that. And then from day 21 through 100, Medicare will cover while you're actually rehabbing, but there may be a copay that you have to pay. If you have other supplemental insurance, they may pick up that copay. Now, Medicare can cover up to 100 days for rehab. However, they almost never cover that long. Most people rehab for a few weeks, and then once they are getting better and they no longer need those skilled services, they are either better and going home to get stronger, or it's getting to a situation where there's really no improvement, and now they're looking at long-term custodial care in a facility. So again, although Medicare can cover up to 100 days, almost nobody actually rehabs for that long. So I always like to let people know that there's that 100-day window, but you're really probably not going to get 100 days out of Medicare. And the facility can only bill Medicare if they're actually providing these skilled nursing types of rehabilitative services to the patient. Okay, so that brings us to the fourth and last payment source, which is Medicaid. And so I've got the Medicaid bullets up here on the screen here for us, because there's a lot of information about Medicaid. So in order for a person to qualify for Medicaid, it's important to remember that Medicaid is essentially welfare, meaning that you have to be needy in order to qualify for Medicaid. So Medicaid requires us to have minimal assets, and there was an overhaul of the system. February 8th of 2006, our Medicaid system was completely sort of overhauled, and it was called the Deficit Reduction Act. And so I've got the bullet points here on the next slide for what you're currently allowed to have. Now, Medicaid is a joint program, federal government, and run state to state. So it's a federal program that is then put into place statewide, and each county has its own Department of Social Services that will actually control and govern and dole out the Medicaid benefits. So if you live in Erie County, it's going to be the Erie County Department of Social Services. If you live in Genesee County, etc. So from state to state, the allowances are going to change. So the rules, overriding rules, are federal, but what an individual person is going to be allowed to keep for income and resources is going to change state to state. And then how they actually implement and roll that out, again, it's going to change county to county slightly. But these are the general rules that we're going to cover. So in the year 2021, these are our Medicaid resource allowances for a person that's going into a skilled institutional Medicaid program. So this is going into a nursing home and you're receiving services in the nursing home. What can you keep? This is what they let you keep. So if you have a married couple and you have one spouse that's going into the nursing home and the other spouse continues to stay at home, the person that's in the nursing home is classified as the institutionalized individual. And the institutionalized individual can only have assets and resources totaling $15,900 of total resources. They are allowed to keep a small life insurance policy if the face value is $1,500 or less. They are allowed to have a burial fund prepaid for themselves as long as it's classified as irrevocable. And they are allowed to keep $50 per month of their income for incidentals like haircuts, etc. Okay, that's not a lot of money, but that's what you're allowed to keep when you're in the nursing home. The community spouse and on Medicaid in the nursing home and wanting to go on to Medicaid. The community spouse, so we have a married couple, one spouse is in the nursing home, institutionalized person. Community spouse is the spouse living at home in the community. So that individual is allowed to keep a primary residence. And you can have a pretty nice house. You can have a house in excess of $900,000 of equity value, so you can have a nice residence. The spouse living at home can have one motor vehicle regardless of its value, so you can have a nice house, a nice car. The spouse living at home is allowed to have other resources, so this is bank accounts, etc. The base amount of $74,820 of other resources available to them. They are allowed to have a burial account prepaid. And out of the monthly income, the spouse that is at home is allowed to keep $3,260 per month to help maintain themselves at home. So this is what we're allowed to keep, okay? So we have a married couple, one spouse is at home, one spouse is in the institution. The spouse is at home doesn't have to be completely destitute, but you do have to have limited assets in order to qualify. But we do want to plan for that sort of worst case scenario, which is one spouse dies and then the surviving spouse ends up having to go into the nursing home. Now we're having to be down to $15,900 of total assets. That's all we can keep in order to qualify for Medicaid. That's not a lot of money. So then what can we do? So it's important to go through a couple things. One is it's important to know that Medicaid identifies assets as either going to be income or resource. Resource is going to be sort of a stagnant pool of assets that's just sitting there. So resources is going to be a house, a vehicle, a bank account, a brokerage account that's just there, cash value of life insurance. Income is going to be anything that produces an income stream out to you. This is going to be Social Security benefit, pension benefit. If you have an IRA, 401k, or a retirement account, it is going to include the required minimum distributions in the income column, which means this is a huge keynote. If you have a large retirement account, like a larger IRA or 401k, you might have $1 million in your IRA. They do not count the $1 million in the resource column. So they do not require you to just spend down that IRA or 401k. They only require you to use the required minimum distributions that you have to take. That is part of your income calculation. That's a really important thing to note, because many clients that I meet with are heavy with retirement accounts, and they are under the impression they're going to have to lose that, spend it all down. That is not the case. Okay. So I do want to get into a couple other points, but I think a couple questions have popped up. So I just want to make sure before I move on that we address those.
If both spouses are institutionalized, do they each get to keep $15,900?
Yes. So if each spouse is in the institution, they are each classified as an institutionalized individual, and in their individual names, they would each be allowed to have the $15,900. They would each be allowed to have a burial account, and they each get to keep their $50 per month for their income. Any other questions?
I'll just answer one that came in about the PowerPoint being shown now. We are going to put this on the registration page after the video is recorded, so everybody will have access to it.
Excellent, great. So if anybody wants the PowerPoint, you can certainly do that. Also, at the beginning of the PowerPoint, I provided my contact information, name, phone number, email address. If you were able to write that down, you can always contact me directly, or you can look me up and send me an email. I'd be happy to pass this on as well. So in addition to requiring people to be down to these levels, these Medicaid resource and income allowances, it's also important to note that there is a look back period. So when you apply for Medicaid, Medicaid is, again, it's welfare, so you have to be needy. Medicaid puts us through this policy of look back. So they basically say you have to be down to these resource levels, and we're also going to look back for the last 5 years to say, did you give away any of your assets in that window of time? Okay. And the theory is, if you have assets and you give them away in that if you did it more than 5 years ago, they're not even going to ask you about it. So we're only worried about the 60 months immediately before going into the Medicaid scenario. So if you make it through 61 months, great, you're good. Okay. So if you do your gifting more than 5 years ago, you're going to be okay there. If you're in the 5-year window, they're going to impose a penalty for any gifts that were made in that window. Okay. And you have to be ready for that to know there's going to be a penalty, and how do we address that? Now, most gifts in that 5-year window are going to be penalized, but there are a couple exceptions. So I just want to cover those. So for example, any transfers that are made between a husband and a wife, that's fine. No penalties for that. So if we have one spouse going to the nursing home and the other spouse continues to stay at home, and we need to remove assets that had been joint out of the institutionalized individual's name to get them into the community spouse's name, that's totally fine by Medicaid. The biggest issue is we need to make sure that the power of attorney allows for that type of gifting. That's why way back at the beginning, I said that gifting is really important in a power of attorney. That is why. Okay. So gifts between spouses, no problem. Those are exempt. There are a couple other exemptions. So for example, if you have a child who's been living in your home and they've been living with you for 2 years or more prior to you going into the nursing home, you are permitted to give your primary residence to that child because they've helped keep you out of the nursing home, and that is an exempt transfer. So that's one of the exemptions. It's called a caretaker child exemption. Another exemption would be if you have a certified disabled child. So it's a child who's certified disabled by the Social Security Administration. We are allowed to make specific transfers to a disabled child. And again, the 5-year the penalty rule within the 5 years there won't apply to that specific transfer. But in general, the general rule is all gifts made within that 5-year window prior to going into the Medicaid system are going to be subject to penalty. I said this before, I want to cover it again. Even though there might be some freebie gifts for tax purposes, the $15,000 annual exclusion gift that you can give away to individuals and not have to report it as a taxable gift, that's freebie, not a penalty or tax reporting, but it is always going to be looked at for Medicaid purposes. So important to know that, okay? So all gifts made within that 5-year window are going to be looked at. In addition, if somebody's going and they want services at home, community Medicaid, where we see a lot of commercials, you know, for certain agencies that are out there. You can pay your loved one for caring for you at home. That's community Medicaid. Community Medicaid is going to be having a 2.5-year look back period. That was actually instituted about a year and a half ago, but then COVID hit, so they haven't really been implementing the look back, but we are going to have a 30-month look back period for community Medicaid too. So the question becomes, well, there's something happens, we need to go into a facility. What's going to happen? If you did your look back, if you did your gifting prior to look back, no problem. If it happens, if you did a gift within that look back period, then we know they're going to impose a penalty. And let's explain how that works. So if you made a gift within the 5-year window of time, what they're going to do is they're going to take the value of the gift, they're going to divide that number by the regional penalty rate, which right now in Western New York this year is $11,054. It changes every year, and it changes from certain areas of the country that you would be in. So in Western New York, that's our regional penalty rate. But let's just say that you took a $100,000 item and you gave it away to somebody within the 5-year window. What'll happen is the Department of Social Services will take $100,000, they'll divide it by the regional penalty rate of $11,054, and they will say, okay, you made a gift in the window of look back of $100,000, that's a 9-month penalty. So what that means is, even though you might otherwise be all the way down to the Medicaid resource allowances, all of your paperwork is otherwise good. If you made that gift within the 5-year window, they're going to say you are not qualified for Medicaid. You are ineligible for 9 months. You have to have some other way of paying for the facility through that 9-month period of time. So if you had to privately pay a facility for 9 months at, let's say, $15,000 a month, that's going to end up being more than what the gift actually was. So that might end up being like $122,000 or whatever it ends up being. So what we want to do is know, A, we want to do our plan in advance. So as we're getting a little older, before we have major medical health crises, we want to try to get these things in place so that we can well clear the 5-year rule. So that's our first goal. But I also want you to know that even if you didn't make it through the 5 years and we are now in a crisis, we didn't have an opportunity to plan in advance, there are still things that we can do in a crisis plan. And it's complicated, and it's more than what I can really get into today. But I do want you to know that there is something called a gift and promissory note strategy. And it essentially envisions taking excess assets that we have. We're not going to make it through 5 years. We have too many resources. What can we do? Well, we can take maybe the excess assets that we have, and half of it we can gift to a trust, knowing that there is going to be a penalty imposed for that. We have to calculate the number of months that that penalty is going to be. And the other half we structure in a promissory note that's going to repay that Medicaid person over the same number of months that the penalty is. Okay, so it's complicated. It's more detailed than what we can really get into today, but I do want you all to know that our goal is to get to people to plan in advance so that we well clear 5 years. But if you did not clear 5 years, there are still things that we could potentially do. We could maybe come up with a crisis plan, or we can also think about doing what are called spend downs. So you can legitimately spend your money on assets, on items or assets or services in the 5-year window, and that's not a problem. So for example, if we have a community spouse living in the home and we have too many cash assets, well, maybe the house needs a new roof, or maybe it needs some renovations, or it needs a new furnace, or the vehicle is old, we can upgrade the vehicle. So to the extent that we have somebody going into the Medicaid system and they have some excess resources, but we can pretty easily spend those down legitimately, that's probably what we would recommend. We would think of legitimate legal ways to spend the money. One of the best ways to spend the money is prepaying for funerals. So funerals are always going to be allowable under the Medicaid resource allowances. You can take advantage of prepaying for your own funeral, your spouse's. Medicaid also allows you to prepay for a burial space item for your children and their spouses. So that is one of the expenses that's really easy for us to spend down excess resources and know that that's going to be okay because it's totally allowable under the Medicaid rules. So again, spending down can be renovations to the house for the community spouse, a new vehicle for the community spouse, any medical equipment that you may have needed. You can even use money to pay somebody to help care for you. So if you've been living in your home and you're having aides come in, you can do that. But I warn you to make sure that that's all above the books, not off the books. We want to make sure that it's recorded, that you're actually keeping track of the number of hours that you're paying an aide and that you're paying them recorded for the services. So for example, if you just pay somebody cash off the books to come and help you and money is going out every month, Medicaid's going to see that in a Medicaid application and they're going to say, well, that's considered a gift, because if you can't prove that it was for services rendered to you, we're going to assume you just gave somebody money. The presumption is always, in the Medicaid eyes, that if you cannot prove what you did with the money, that it was considered a gift and they will impose a penalty. So you can spend your money, just keep a record of it. You can take a vacation, whatever you might want to do, it's your money, but you have to be wary. If you go into the Medicaid system, they're going to be looking at all transactions and you have to be ready to provide documentation for each of those transactions. And in the general rule is that they are only looking at larger transactions. However, they have the right to look at everything. So be prepared to provide documentation for any transaction that happened in the last 5 years of $1,000 or more. So if it's a deposit, a withdrawal, a check, a transfer, etc., be prepared to have to tell Medicaid what that was for and get all that stuff together. All right. So before we wrap up, I just want to cover a few last items to talk about avoiding probate and making life as simple and easy as possible for your family after you pass away. When somebody passes away, I've already mentioned that the last will and testament is going to govern the control of assets after that person passes away and designate what happens with those assets. But we can make things cleaner and simpler without even having to use a will by making sure that we have maybe a joint owner attached to an asset or a designated beneficiary. So it's important to know with bank accounts, you can add a joint owner or a designated pay on death beneficiary. The difference between that is joint owner means that you're actually giving ownership to your family member or your trusted person now. So I'm alive and I'm actually giving ownership to this other person now with me. They can access it now as well. If you don't feel comfortable with that, you can just name them as a pay on death beneficiary. You can do that right at the bank. So they'll have immediate access to that account, immediate access to money after you pass away to pay any final expenses that they might need. You can name a beneficiary on just about every asset. So life insurance can have a beneficiary, IRAs, annuities, etc. All of those things can have beneficiaries. When we talk about beneficiaries for annuities, it's really important to know, I want to cover that annuities have very harsh treatment by Medicaid. So if you have annuities and you're going into the Medicaid system, Medicaid will require you to name the Department of Social Services as the beneficiary. If you have a living spouse, you may name your living spouse as the primary beneficiary there, but if you do not have a living spouse, you are going to be required to name the Department of Social Services as the beneficiary. So that has harsh treatment, and we always want people to know that. Who's required to be named as the beneficiary on an annuity when you're getting into the Medicaid system. But if you're not going into Medicaid, you can name a beneficiary on your annuity and it will pay out to whoever you've designated there. Additionally, you can also take steps to change title ownership of assets prior to you even passing away. One of the most common things that people will do is transfer ownership of their primary residence to perhaps their children while mom and dad retain rent-free life use, and that's called a life estate. A deed where we transfer ownership to the kids and mom and dad retain rent-free life estate on the property for the duration of their life. So it avoids probate. After you die, the kid's already on the title, they own the property. It actually makes things simpler for Medicaid situation. You've already given it away. If you did it more than 5 years ago, we've then tried to shelter that house. Wonderful. But the thing I always want people to be aware of is if you are adding your children as straight up owners on your property, remainderment owners, if your children run into any financial difficulty, that could expose your house as well. So if they get into a car accident, they go through a bankruptcy, they're going through a divorce, etc. You may want to be cautious about who you're adding onto your deed. One of the things that we can do to avoid that exposure is use something called a trust. And a trust is a legal entity that is created to hold on to assets. And under the umbrella of trust, there's revocable and irrevocable. A revocable trust is a trust that you create and you can freely amend it, change it, revoke it, or cancel it at any time, and you have control over all the assets in that trust. A revocable trust will avoid probate for any of the assets that are owned by that trust when you die, because they're not in your name anymore. They're in this trust entity that continues on after you pass away. A revocable trust can put protections in place for the benefit of your children or your grandchildren, etc. That's all wonderful. But a revocable trust does not give you any protection from a nursing home because you have access to the assets. Therefore, those assets are available to you for the nursing home and to Medicaid. So the irrevocable trust is an entity that can be created by you where you take assets out of your name. You put those assets into this irrevocable entity. Someone else is the trustee. It could be a child or multiple children. And you basically relinquish ownership and control over the assets that are in that trust. Once you've cleared 5 years, the assets that are in that trust are now protected from Medicaid. At the end of your life, those assets now avoid probate. They go on to whoever the designated beneficiaries are. You can also put protections in place for the benefit of your children, your grandchildren, etc. So you just want to keep all that in mind. Avoiding probate, we can do multiple things, but if you are also looking to avoid a Medicaid nursing home type of situation, then you need to be talking about doing an irrevocable type of trust scenario. So I've covered a lot of ground. Did we get any additional questions that popped up?
We actually did. Is the 5-year look back considered federal or state?
That's federal. So the 5-year look back is a federal rule. There have been discussions about increasing that from 5 years to 7, but that has not happened. Previously, prior to the Deficit Reduction Act, February 8th of 2006, it used to be a 3-year look back rule. Then it became 5. Right now, again, we're at 5 years. And even though there's been some discussion about maybe it being extended, we don't have any legislation coming forth that we know of for that right now. Important to know, if they do extend it to 7 years, it is very likely that they will grandfather in people who made their gifts prior to the change in the law, because that's what they did last time. So last time, anybody who made a gift prior to February 8th of 2006 fell under the old rules and the 3-year rule, and they grandfathered everybody in. So my hope would be if they do extend it, they will grandfather in anybody that did their gifts prior to. Next question.
Is there a cost to add money or stocks to a revocable or irrevocable trust as you earn over the years?
So obviously for creation of a trust entity, there is going to be cost for that. So, and that will depend on who you're working with. It will depend on the complexity of the document, what you're putting in there. But if you're just changing ownership of an account that you can do directly with your financial advisor, there's no cost for you to do that. You can do that directly at your bank or your financial institution, or work with your financial advisor to change ownership from your name individually to the name of your trust.
And one more. There's one more. Is there an average fee that you can discuss for working with an attorney to complete the documents you've been discussing?
Sure. So I can only talk about what our office charges, because I really don't know what other offices charge, other than I believe that we're within the realm of what attorneys charge in Western New York. So for our office at Pfalzgraf Beinhauer, if we do just a consultation, for example, somebody wants to sit down and talk to one of our attorneys and get ideas and talk about all these things in detail with their specific resources and income involved, we charge a flat rate of $350 for up to 90 minutes to do an individual consultation with somebody. So $350 for a consultation. If somebody came to me and wants to just do a last will and testament, a disposition of remains, a healthcare directive, and a power of attorney, those 4 basic documents we talked about, those are $750 for those 4 documents. So if we're doing a married couple, $750 each, $1,500. If we were talking about doing like an irrevocable type of trust, we're looking to protect several $100,000s of assets, our house and maybe some of the cash, etc., from a nursing home down the road, that overall plan would probably be about $5,500, somewhere in that range. But it really is going to depend on what assets are going in, the complexities, etc. I think one other question might have came in. Maybe not. Oh, you're muted, I think there, Christine, sorry.
Looking through here. Okay, so you got how are costs affected starting with irrevocable and then getting irrevocable trust?
How are the costs effective?
Right. Okay.
I'm not sure what that question is, but so generally speaking, the cost of a revocable versus an irrevocable trust, they're going to be pretty similar because the entity is required to be created by way of a legal document. There's a little bit more work with an irrevocable trust because we have to order a separate tax identification number for that trust from the Internal Revenue Service. So it might be slightly more expensive to do an irrevocable trust versus revocable, but they're within the same realm. So you maybe $4,500, $5,500, $6,000, something in that realm should cover somebody, depending on again what's going in there. If you're talking about $1 million going in, then that's a lot more assets, more work, then the cost is going to increase for the work that's going into it. Any other questions that anybody has? No? Okay.
Just looking through here, I don't see any.
Okay, great. So we're approaching sort of the end of the hour. I'm happy to take any other questions if anybody wants to put them into the Q&A. Otherwise, I will wrap up, and I will again reiterate that all of my contact information is available. You can certainly reach out to me if you have follow-up questions to what we've covered today. I'd be more than happy to try to address an email or a phone call to anybody. And the biggest thing I want to impart on everybody is to think in advance. To the extent that we can get these things done in advance, that's wonderful. But also, if you didn't think in advance and we have a crisis, elder law attorneys can still help you. You want to work with somebody that does elder law. It doesn't necessarily have to be me, but I want to make sure that everybody is aware that there are attorneys in the Buffalo area who are here that are skilled, that can help you and help your family through the process. I thank you all for your time. And again, I thank Christine for hosting for us today and helping me through the process as well. But it's been great working, seeing all of you, and I appreciate your attendance.
Thank you, Linda. Thank you for that comprehensive presentation. It was great. Thank you all for joining today. Hopefully you will join us again tomorrow. Our topic is on scams and fraud targeting older adults and how to avoid them. It'll be at 10 o'clock. And there's also a brief survey that will pop up after this ends. Please take a minute to fill it out. We'd appreciate it. Again, thank you, Linda.
Thank you. Have a great day, everybody.
Thank you.